the land acquisition case. There is the objection that we not meet the second. Thereafter, we filed the land. That was rejected. Now the urgency is that the amount has been, the compensation amount has been already deposited in the bank. On 7th of May, the execution date is there. On that date, they will finally get the amount from the bank. How many paid may be listed? All the defects have been removed.
Reading list serial number 45 restoration matter पिछला वीक में हम एक्सेप्ट किए थे तो लेडी सी बोली थी कि आप सरेंडर कीजिए तो हम सरेंडर करके सरेंडर सर्टिफिकेट भी फाइल कर 1 बजे हम बुला रहे थे सरेंडर के लिए
13 1 3
30.
what is it?
Restoration.
Restoration is not urgent. Restoration is not urgent matter.
From supplementary cause list.
आपकी गलती से डिस्कस हुआ होगा ना. Restoration is not urgent.
Serial number 2 BA 2650 of 2026.
Wait for your turn before you move back. Yes.
Offense under section 318(4), 319(2), 363, 360, 336(3), 338, 366 of the 98. Petitioner in custody since 17th of December 2025. Allegation against this petitioner is that NDC page 30. Lord Ramkiriya Sharma gave a written report before the Cyber Police Station stating therein that one Facebook Yono ID was contact in which he confirmed and 1,90,000 rupees was deducted from his account. It is also alleged that said amount come in my account. This is the allegation. My submission before this court is that neither Yono ID in which all was there what belongs to me. When this Yono ID was created, at the relevant time my mobile number was not there, my email ID was not there. Said I am the bona fide account holder of the Union Bank of India in which amount has come. मुझे मेरा सबमिशन यही है कि यदि आज हम यहाँ खड़ा है
वो पैसा का क्या हुआ?
पैसा मेरे अकाउंट में और उसके बाद और क्या हुआ कि जब मैं ये चीज खबर करने के लिए जानकारी के लिए ब्रांच मैनेजर के पास गया तो वहीं से हमको अरेस्ट कर लिया गया। मैं ये डिनाई नहीं कर रहा हूं मेरे अकाउंट में नहीं आया, मेरे अकाउंट में आया है, लेकिन मैंने ना डिमांड किया है ना कुछ किया है। हम बोनाफाइड अकाउंट होल्डर हैं।
You admit that this money does not belong to you.
Yes.
You admit it.
Yeah, I admit.
Should I record it?
Yes.
That this money does not belong to you.
Yes.
Any other case instituted against you?
No. I have stated in para 21 no antecedent.
What do you say?
फिर ये बोले इनका सबमिशन था कि दैट अमाउंट इज लेइंग इन हिज अकाउंट. I have memo of evidence left wherein it is clearly mentioned अनुसंधान क्रमिक कांड के पास भी अभी अंकित कुमार द्वारा अपने यूनियन बैंक अकाउंट इंडिया खाता संख्या इतना दैट इज एलएच अकाउंट से दिनांक 27/11/25 से दिनांक इतना तक अलग-अलग तिथियों से यूनियन बैंक ऑफ इंडिया रांची शाखा जाकर विभिन्न चेक के माध्यम से कुल 1,15,000 रुपया की निकासी गई है. उप निकासी संबंधित सीसीटीवी फुटेज उपलब्ध. That amount is not like
DA number 250.
another evidence I follow. In confessional statement, he stated that he cheated this amount with along with other two actors.
That's
In investigating further, he is connected to other co-accused on the date of the
therefore it
incident.
is organized crime.
Yes. But that accused, that person was not made in accused in the present case.
BA number 2650 of 2026. Heard the learned counsel appearing on behalf of the petitioner. The counsel for the petitioner submits that the petitioner is merely the account holder of the account in which the amount of rupees 1,90,000 has been credited. He submits that the allegation is that the complainant was that the informant was tricked by a SBI link on Facebook, on account of which, pursuant to which the amount was debited from the account of the informant and credited in the account of the petitioner. The learned counsel submits that at the time when the alleged incident is said, he submits that neither IT belongs to him, nor the
योनो अकाउंट अपग्रेड करने के लिए उनकी एसबीआई अकाउंट में योनो अकाउंट होता है
इनका submission, nor at that relevant point of time the phone belonged to the petitioner. However, during the course of argument, he does not dispute that 1,90,000 does not belong to him. The learned counsel for the state has opposed the prayer and has submitted that the petitioner has that there is connivance of two more persons, pursuant to which the amount has been credited in the account of the petitioner, and it has come during investigation that the petitioner has thereafter withdrawn an amount of rupees 1,15,000. He has also submitted that the petitioner also confessed his guilt. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the petitioner that the defrauded amount was credited in the account of the petitioner, and it has also come during investigation that the petitioner had also withdrawn a substantial portion of the state amount, this court is not inclined to enlarge the petitioner in being instituted.
Serial number 3, BA 2854 of 2026.
Other offenses are section 75, 79, 319, and one of the various and also under section 66E.
Can you read the FIR?
Page 30. Comments is very aware of the such this such
What's her age?
Instagram चला
एज बताइए कितना है उनका? लड़की का एज
is 12 less but
12 years.
but during investigation about 14 years.
पढ़िए पढ़िए पढ़िए.
इंस्टाग्राम चलाती थी। वर्ष 2024 माह दिसंबर में मेरी बेटी के आईडी में हमारी सचिन सच का इंस्टाग्राम का फ्रेंड रिक्वेस्ट आया था। तो आईडी से मेरी बेटी का चैट होना आरंभ हुआ और चैट होते होते दोनों के बीच बातचीत होने लगी। इसी क्रम में बातचीत होते होते एक लड़का अपना वास्तविक नाम छिपाते हुए अपना नाम ऋषि सचिन से बताया। वो लड़का ने मेरी बेटी को ब्लैकमेल करने लगा, अपने झांसे में लेकर मेरी बेटी को डराते हुए धमकाते हुए अश्लील वीडियो का मांग किया, जिससे मेरी बेटी डर गई और अपना मोबाइल नंबर से आपत्तिजनक वीडियो को लड़के के मोबाइल नंबर पे भेजी। इस बात ये निश्चित
आगे पढ़िए.
आगे
आगे पढ़िए.
जब मेरी बेटी ने सचिन सच वाले इंस्टाग्राम आईडी के लड़के के साथ बात करना छोड़ी तो सच ने नाम वाले लड़के ने मेरी बेटी का आपत्तिजनक वीडियो को सचिन सच नामक लड़के को भेज दिया। सरफराज नामक लड़के ने सोशल मीडिया व्हाट्सएप पर ऑनलाइन वायरल मैं से अश्लील वीडियो का जांच किया तो पता चला कि सचिन सच इंस्टाग्राम वाले लड़के का वास्तविक नाम सचिन सच है, दिल्ली जॉब का है। महाशय इस अश्लील वीडियो के फैलने पर मेरी लड़की मिसलिएशन। As per the first information report, the informant doesn't say that this petitioner ever met with his daughter. That is the evidence. That's what the FIR. At which the case under section 66 IT Act is made up, and this is section 66 E of the IT Act. At which that is valuable in nature.
66 E of the IT Act.
Yes, I will.
If a objectionable video
Yes.
of a minor girl is made viral.
Not made by me.
No, not made by you, but you forwarded it.
On this.
That is the allegation that you have forwarded.
Yes, I forwarded
So
it.
you have only.
But see,
Sharing with one is as good as sharing with many.
Yes, sir.
So
Yes,
allegation is that you have forwarded the video
Yes,
to
that's
one
the
Sarfaraz.
Yes, sir. At that circumstance, the maximum punishment is violence. 3 years in the offence is valuable.
Under which section?
Section 66E of the
That
Act.
is 66 information.
Whoever intentionally or knowingly captures, it's not illegal, publishes or transmits the image of a such and such criteria of any person without his or her consent, that circumstances violating the privacy of that person shall be punished with imprisonment with wage 10 to 3 years.
Why not 67A will come into force?
67A. The case has been registered under section 67B and 1B. And ma'am, can you see
So
section
67B
Yes.
and 67A punishment for publishing or transmitting material containing sexual
Yes, ma'am.
explicit. And 67B is
66.
yes, use as C 67B.
Punishment for violation of privacy.
67B.
B. 67B. 67B is malice. That is a different type of allegation.
No, they are
Punishment
registered
for
the
publishing
case.
or transmitting material objects children in sexually explicit. That is not applicable in my case. That is not applicable. And once can we see section 77B of the Act?
Your 66E is also not applicable. Either 67 or 67A or 67B.
Then my let it be Monday. I will also place some judgment points for in this case
Not
for
judgment.
consideration.
They
Because
will get judgment.
as per the FIR, the case has not been registered under those sections.
No, it has been registered under 67B. How do you say?
So 67B what's
तो चार्ज फ्रेम होने दीजिए उसके बाद आइए.
what 67 says?
चार्ज फ्रेम हो गया आपका? चार्ज फ्रेम हो
मंडे को
गया?
बता रहे मंडे को बता रहे चार्ज फ्रेम मंडे.
कब से कस्टडी में?
हम कस्टडी में है इस केस में है 1 दिसंबर 25 से. Master, he was a student of Malar's diploma electrical doing Malar's.
आप नेट से चेक करके बताइए चार्ज फ्रेम हुआ है.
मंडे और कुछ 24 नंबर कोर्ट में कुछ जो केस वगैरह है ऐसा.
तो हम ऐसे ही रिजेक्ट कर देते हैं उसके लिए क्या बोलने का?
हाई स्कूल जगह पर
कौन
बिकॉज
जगह है?
deciding that the result matters as per the first information report matters and the statement of the victim is also
और ये
important.
जो पॉक्सो 12 एंड 17 है इसमें भी क्या 3 साल सजा है?
इसका किसी भी एबेटमेंट का किसी नहीं है इसमें कुछ वो एबेटमेंट का मतलब दिस इज एडमिटेड केस फॉर दिस
वही
एज
तो
फॉर द
चार्ज फ्रेम होने के बाद आइएगा. कम आफ्टर फ्रेमिंग ऑफ चार्ज.
चार्ज वाले देख के बता देते हैं उससे चार्ज कोई हमारे रहेंगे सीख कर देंगे जो सेल्फ फेल हुआ है।
During the course of arguments, the learned counsel for the petitioner submits that the sections under which the case has been registered are not read out. However, he submits that he is not sure as to whether the charge has been framed so far or not. At his request, post this case on Monday. सिर्फ चार्ज फ्रेमिंग वीक का ऑर्डर भी लेके आएंगे, कौन केस में
ये
कितना
हुआ
नहीं हुआ तो हम आपको बेल नहीं देंगे, अभी बता देंगे। फिर चार्ज फ्रेम करने के बाद में इतना हम यहाँ पे थोड़ी बैठ के डिसाइड करेंगे कौन कौन सा सेक्शन बनता है। नीचे है ना सब, मेंशन तो किसी ने नहीं किया, आप एकदम रेगुलर करें।
From Delhi cows list, serial number 1, under heading for final disposal, WPS 3754 of 2023.
We have 5 short synopses and list of dates also. On 21/6, yes.
Prayer for passing to order 6 of 2023 in accepted passed by the respondent 5. Provide a recommendation for regulation of service of the petitioner and return to the respondent shall on the ground that post was not sanctioned in view of regulations.
So, first question, do you want to say that you qualify under this rule or not? According to you, do you qualify under this rule or not? Under this amended regularization rules 2015, are you entitled for regularization
Yes,
under this rule? Because नहीं, हमको दो चीज़ है ना, एक तो you are claiming regularization otherwise, and secondly is that you are claiming regularization pursuant to a rule, right? Annexure 10 has been passed pursuant to a rule. So you are claiming regularization on the basis of the rule.
On the basis of long tenure of service.
So you are not claiming regularization on the basis of the
I
rule.
am no, I am stating that my regularization recommendation has been returned only on the ground of the post was not sanctioned, that is their strength. My submission with regard to this aspect of the matter, that vacancy was advertised, and all the candidates have appeared and they passed in the examination, and thereafter appointment has been made. And thereafter the petition.
What is the date from which you are working?
Madam,
Since when are you working?
yes, I have been working. We have been working under 27/5/97, 5/12/98, 9/7/2001, 16/6/1997, 9/7/2001, 5/6/1993.
Why so many days? Why so many dates?
ये 8 पिटिशनर का बता है, 8 पिटिशनर है, सबका अलग अलग बता रहे हैं, हम इसमें लिखे हैं लिस्ट ऑफ डेट्स में.
Okay. So is there any letter of appointment is issued to you? Because you say that you have been working on contractual basis as daily wage.
Yes. That is yes. I have been working.
Any letter issued to you?
But in the letter of in the recommendation by which they themselves stated that I have been working such and such.
Where is that?
Lecture 7 or lecture 7 again.
Page number?
lecture 6 lecture 6 सही है. Page number 62. Page number 62.
Yes.
मतलब ये सहायक बंदोबस्त अधिकारी लिख रहे हैं डिप्टी डायरेक्टर लैंड रेवेन्यू डिपार्टमेंट को, ये उपप्रश्न 43 सफाई मोहर की सूची जिसमें जन्मतिथि कालक्रम एवं कार्य सेवा काल की अवधि अंकित है. इन सभी सफाई मोहरियों की नियुक्ति विज्ञापन निकालकर लिखित परीक्षा के आधार पर की गई है. अतः कुल 43 सफाई मोहरियों की सूची इस प्रकार है. तो
आप कौन से
सीरियल नंबर? जैसे पेज नंबर 64 में बुधन सोरेन पिटीशन नंबर 2.
64 सीरियल नंबर
21.
21.
उसी तरह सीरियल नंबर 24 में भी श्रीमती बाहा मुर्मू पिटीशन नंबर 4. फिर 33 में है चंदू मारंडी पिटीशन नंबर 3. ये
आगे.
और उसके बाद जो श्रीमती लखीमती चोड़े, ये सीरियल नंबर 65 पेज में है.
एक सेकंड.
और
सीरियल नंबर
43 मार्शल मारंडी,
ये पिटिशनर नंबर
8.
तो सुखीमती चौड़े इस पिटिशनर नंबर
5.
पिटिशनर 5 और
एक है 64 में सीरियल नंबर 39 श्री चंदेश्वर सोरेन पिटिशनर नंबर 7.
39 P7 कौन बचा?
और पेज 33 में श्री तारापद सोरेन, ये पिटिशनर नंबर 1 है.
तारापद
पेज 63 इसी में
63 सीरियल नंबर
19 एकदम नीचे
90. ये पिटिशनर 1 है.
हाँ, उसके बाद उषा रानी मुर्मू फिर सीरियल नंबर इसी पेज में सीरियल नंबर 10 में पिटिशन नंबर 6. सबका लिखा हुआ है कितना साल से काम कर रहे हैं. उसके बाद फिर एनेक्चर 7 है, उसमें भी यही चीज है कि वो नियमितीकरण का ये उल्लेख किए हैं, जो भेजा गया है नियमित. उसके बाद 8 सीरीज में और डिटेल्स में लिखा हुआ है कि लिख रहे हैं ये पेज नंबर 68, इसमें भी हम लोग का नाम है. जैसे पेज 69 में सीरियल नंबर 7 में पिटीशन नंबर 6 का है जो 93 से का उजरत कार्ड प्रारंभ करने की तिथि 593
6
हाँ 6 का
हाँ
और उसके बाद जो
और बाकी का नाम
हाँ
बताइए।
उसके बाद चंदू मुर्मू नेक्स्ट पेज में 69 में सीरियल 16 इसमें है पिटीशन नंबर 3 ये काम कर रहे हैं 2001 से 9/7/2001 से उसके बाद पिटीशन नंबर 5 जस्ट लोकीमुती चोड़े सीरियल 18 में है ये 2001 से काम कर रही है
पिटिशनर नंबर
पिटीशन नंबर ये 5
पाँच।
लोकीमुती चोड़े उसके बाद जस्ट 19 में है तारापद सोरेन ये पिटीशन नंबर 1 उसके बाद है फिर है जो जस्ट उसके 70 पेज में श्रीमती बाहा मुर्मू ये 16/6/1997 से ही काम कर रहे हैं
सीरियल नंबर
23
पिटिशनर नंबर
4 और उसके बाद 24 में है बुधन सोरेन ये भी 98 से काम कर रहे हैं पिटीशन नंबर
2
उसके बाद जो सीरियल नंबर 27 पिटीशन नंबर 7 हो गया चंद्रेश्वर सोरेन ये 2001 से कर रहे हैं और एक है लास्ट में मार्शल मारंडी ये सीरियल नंबर 32 2/6/97 से पिटीशन नंबर 8
उजरत दर पे भुगतान मतलब व्हाट इज उजरत दर व्हाट इज उजरत दर पे भुगतान
पीस
पीस रेट just थोड़ा fact समझ लीजिए. The learned counsel for the petitioner has submitted that the petitioners are working on the post of Muhriar on contractual basis as daily wager, known as Safai Muhriar in Settlement Office Durga since 27/5/97, 5/2/98, 9/7/2001, 16/6/1997, 9/7/2001, 5/6/1993, 9/7/2001 and 2/6/1997 respectively. Petitioners लिखे ना petition number 1 to 8 लिखे. For that purpose, he submits that it is an admitted fact on record and refers to Annexure 6 at page 62 and submits that the name at serial number 10, 19, 21, 24, 33, 39 and 40 are that of petitioner number 6, 1, 2, 4, 3, 7 and 5 respectively. कौन सा चूक गया? Yes. And 43 में P8 respectively, wherein the period of work has been shown as follows. इसको चार्ट में बना देंगे. He has then referred to Annexure 7 and has submitted that their name and the date from which they have been working has been mentioned in the chart, which is the document of the respondents. He has referred to page number 68 and the names at serial number 7, 16, 18, 19, 23, 24, 27, 32 with respect to petitioner number 6, 3, 5, 1, 4, 2, 7 and 8. And as per the, however, during the course of arguments, it transpired that as per the chart which is being relied upon by the petitioner, the services has been shown to be irregular services and payment on piece rated. Is Ujrat is piece rated, ना?
उजरत का मतलब पेमेंट बेस्ड ऑन वेज रेट।
और
वेज रेट
wage rate. क्या बोल रहे हैं? उजरत is what?
उजरत का मतलब वेजेस।
No, it has come in one of the order passed by this honorable court. It is their case, circular that they are working on piece. They are not daily basis. They are working on piece rate. I'll show that paragraph.
Okay. Irregular and ujrat that we can't give. I do not know the English of this. इसका इंग्लिश देखिए तो उजरत का क्या मतलब है? उजरत। ठीक। फर्दर प्लीज। यस। दूसरा कोर्ट में जाना है, जा सकते हैं। मल्टीटास्किंग एक कोर्ट में नहीं हो सकता, दूसरा कोर्ट के साथ मल्टीटास्किंग नहीं हो सकती। यस प्लीज।
All this recommendation has been time and again sent by the authority for regularization of this service pursuant to the earlier order of this court. Thereafter, they have passed the order, that is annexure 10, page 76.
Your names were sent for regularization, and then they have considered your case.
They have considered and they have considered, but they have rejected for regularization on the ground that एक तो लिखा है कि आवेदन प्राप्त करने की अधिकतम अवधि अधिसूचना निर्गत होने की तिथि 20/6/19 से अधिकतम 6 माह की होगी, किंतु 6 माह की अवधि व्यतीत हो चुकी है।
Okay. Anyway, recommendation.
ये रिकमेंडेशन जो है, ये ऑर्डर 2015 का था रिकमेंडेशन, ये 3 बार भेजे हैं। रिकमेंडेशन का डेट भी देख लिया जाए। एक भेजे हैं 29/1/2016, that is annexure 6.
Annexure 6 is?
Annexure 6 page 62, इसमें 29/1/16 रिकमेंडेशन तक के भेजे रिकमेंडेशन के लिए। उसके बाद फिर annexure 7 है, ये annexure 7 को वहाँ से जवाब आया कि आलोक में जांच का नियमानुसार आवश्यक कार्रवाई करते हुए प्रतिवेदन विभाग को उपलब्ध कराना सुनिश्चित करें। ये फिर रिमाइंडर दे रहे हैं कि जो संशोधित नियमावली के आधार पर, नियमाकरण के आधार पर समय सीमा के अंदर कार्रवाई करने का अनुरोध किया गया है। ये पहले भी अनुरोध किया गया था, लेकिन समय से नहीं हुआ। 2/3/2020 का लेटर। उसके बाद एनेक्चर 8 सीरीज में है 24/1/2023। इसमें है कि इसमें भी असिस्टेंट सेटलमेंट ऑफिसर भेजे, उसमें लिख रहा है कि सेवा।
Okay, anyways, this rider that it has not been timely submitted is not
हाँ,
correct.
that is there।
और आगे बाकी
उसके बाद मेरा कहना है कि अच्छा निर्गत होने की तिथि क्षमा होगी। प्रासंगिक पत्र झारखंड
नहीं, ऊपर पैरा 1 नहीं पड़ेगा।
अच्छा
उसको कैसे
झारखंड सरकार के अधीनस्थ अनियमित रूप से नियुक्त एवं कार्यरत की सेवा नियमितीकरण नियमावली 2015 के 3 के अनुसार यदि किसी कर्मी द्वारा खारिज पर स्वीकृत न हो तो उनके सेवा नियमितीकरण पर विचार नहीं किया जाएगा। खारिज पर स्वीकृत, पोस्ट सैंक्शन।
Your post is sanctioned.
हमारे पोस्ट मैंने मेरा केस है कि हमारा अपॉइंटमेंट हुआ एडवर्टाइजमेंट के बेसिस पर उनका।
एडवर्टाइजमेंट के बेसिस पर?
हाँ, एडवर्टाइजमेंट पे।
कहाँ है एडवर्टाइजमेंट?
रिकमेंडेशन में भी तो लिख रहे हैं एडवर्टाइजमेंट तुम लगाए हैं सप्लीमेंट्री, और मेन पिटीशन में भी लगाए।
Where is the advertisement?
यस मैम, सप्लीमेंट्री एफिडेविट में काइंडली
Advertisement बताइए।
एडवर्टाइजमेंट दोनों लगाए। जितना
तो जब एडवर्टाइजमेंट होगा तो सबका तो सेम डेट ऑफ अपॉइंटमेंट होगा ना.
सेम नहीं, अलग अलग डेट है ना.
Where is that advertisement?
सप्लीमेंट्री एफिडेविट मैटर 2/2/26 को फाइल किए थे, इसमें दोनों एडवर्टाइजमेंट लगा दिए हैं. एनेक्चर 11 है, पेज 7 और पेज 6 का जो है ट्रेस कॉपी लगाए हैं एनेक्चर 7.
I don't get your. Okay.
स्थायी निवासी के हम दिए हैं. आवेदन की अंतिम तिथि 20/6/97 तक है. स्थायी मौलिक
नहीं, ये आपका 92 से ही एडवर्टाइजमेंट चल रहा है.
92 में भी एडवर्टाइजमेंट
लेकिन आप लोग में से कोई 92 का तो अपॉइंटमेंट
है.
कौन?
एक आदमी है 92.
एक 92 भी है.
हाँ 92 है, बता दें.
93 है.
हाँ
93. Okay, this is one advertisement. This is
हाँ, उसके बाद
97.
फिर
This
एडवर्टाइजमेंट.
is 13. And what was the nature of advertisement?
इसमें भी 10 बजे उसके बाद 2001 में भी
नहीं, आप एक एडवर्टाइजमेंट पढ़िए तो किस व्हाट इज द नेचर ऑफ एडवर्टाइजमेंट. You have been called for contractual
सफाई
basis.
नहीं, कहीं लिखा नहीं है. सफाई मोहरी के पद पर अनुसूचित जाति एवं अनुसूचित जनजाति के उम्मीदवारों को नियुक्ति की जाएगी. इसकी न्यूनतम योग्यता मैट्रिकुलेशन होगी. आवेदक को लिखावट सुंदर स्वच्छ होना चाहिए. इच्छुक व्यक्ति उक्त निर्धारित पद के लिए विहित आवेदन.
So as per the advertisement, you participated, and as per the advertisement, it was the sanction post.
हाँ यस. और एग्जाम भी हुआ था और एग्जाम में पास भी किए हैं. जो एनेक्चर 6 में उनके द्वारा लिखा हुआ है भी है कि सभी सफाई मोहरी की नियुक्ति विज्ञापन निकालकर लिखित परीक्षा के आधार पर की गई.
ठीक. Then, but in spite of that, they have declined your regularization by saying that it is not a sanction post. जब आपका सैंक्शन पोस्ट में अपॉइंटमेंट हुआ तो रेगुलराइजेशन का क्या काम है? यू आर ऑलरेडी अ रेगुलर एम्प्लॉय. आई डोंट गेट इट. When the appointment is again sanctioned post pursuant to an advertisement, why is the need for regularization? Where is your appointment letter?
लेकिन
Where is your appointment letter?
अपॉइंटमेंट लेटर तो इसमें नहीं है, लेकिन एक्सपीरियंस सर्टिफिकेट.
इससे क्या मतलब है? If your appointment is again sanctioned post pursuant to advertisement, why do you need regularization? It is not an irregular appointment according to you. You participated in the selection process. There was a written examination and you qualified, and then you were appointed, right? Then where is the need for regularization?
इसमें कोई सैलरी वगैरह कुछ तो
नहीं, इससे क्या मतलब है? आपका अपॉइंटमेंट लेटर हुआ होगा ना भाई. मेनी पीपल मस्ट हैव पार्टिसिपेटेड. यू मस्ट हैव बीन सिलेक्टेड. वेयर इज द अपॉइंटमेंट लेटर? बताइए. तो आपको पूरा ही एरिया सब सैलरी सब मिलना चाहिए. फिर क्या रेगुलराइजेशन क्यों होगा?
हमको तो
आप हमको बताइए. इज इट नॉट कॉन्फ्लिक्टिंग?
काम कर रहे हैं.
आप कितना भी में भी काम कर रहे हैं. इज इट नॉट कॉन्फ्लिक्टिंग that you say that you were appointed pursuant to advertisement again sanction post?
अगर सैंक्शन के बारे में तो हमको आइडिया
भाई एडवर्टाइजमेंट में लिखा है ना सैंक्शन पोस्ट.
नहीं लिखा.
आप तो बोले
ना ये चीज नहीं लिखा.
नहीं.
ये चीज कहाँ
You see, in a selection, you were at least you were inducted just a moment.
ये लिख रहा है कि सफाई मोहरी के पद पर अनुसूचित
पद पर और क्या पद?
है?
पद किसको बोलते हैं? When they are advertising against a post, pad is post, right? Number of persons must have participated in the selection process, and you were selected.
Those who have been selected have been working, and they have been given 250 rupees.
You show me that you were selected pursuant to that. कहाँ है आपका select? अगर आप selection हुआ है तो कोई select list होगा, कोई appointment letter होगा. Where is that? अगर Mr. Mishra, you just tell us one thing. If 100 persons participate in the selection process and 10 have been selected, तो 10 का select list होगा ना?
नहीं 40 आदमी का 43 आदमी का सिलेक्शन हुआ है, उसी का तो ये रिकमेंडेशन.
आपका appointment letter का. And if you have been selected by virtue of a regular selection process, why do you need to be regularized? I don't get it. Why do you need to be regularized? You are already appointed against a post pursuant to an advertisement.
उसमें क्लियरिटी नहीं है ना, एडवर्टाइजमेंट निकाल के काम कराया जाए.
ऐसा तो नहीं है.
यही है, इसे एडवर्टाइजमेंट है ना, बेस कोई स्पेस स्केल है ना, कुछ है, सिर्फ एडवर्टाइजमेंट निकाला है. बेस स्केल
एडवर्टाइजमेंट निकाल के आपका सिलेक्शन हुआ, इसका कोई लिस्ट है?
इसका इसी का तो लिस्ट दिखाया है. ये जो सिलेक्शन हुआ है उसी जो इतना जो चार्ट बना है, चार्ट में तो सब लिखा हुआ है, सब एक बार एनेक्स.
चार्ट कैसे बनता है हम लोग को?
चार्ट तो
you have to make out your own case, right? You have to make out your own case. When you say that you were selected pursuant to an advertisement in the year 1993, एक का बताइए, 93 का कौन सा डॉक्यूमेंट? Selection of 1993.
ये है श्रीमती उमा रानी मोदी.
सिर्फ नाम और चार्ट से थोड़ी होता है.
ये 593 से ये काम कर रहे हैं. 30 साल तो
कहाँ लिखा है कि 593 में she was selected pursuant to this, and where is your letter of appointment? If you were selected,
state is not also not disputing this fact that I have been discharging duty since 93.
it is another thing that you have been discharging your duty since 93. They are not disputing this. But you said that you have been selected pursuant to a selection process.
I am I am saying that advertisement was published, and on the advertisement I participated, and I have been working since thereafter.
You have participated and you were selected.
I have been selected, that's why my lord.
If you have been selected pursuant to an advertisement against a post, then where is the question of regularization? You are already a regular employee.
Against the post तो इसमें बोल रहे हैं, ये पोस्ट जो है सैंक्शन ही नहीं है. गुजरात भोगी के पद पर हम जो काम कर रहे हैं, बोल रहे हैं ये सरकार से सैंक्शन नहीं.
Yes, what is your case? What is the nature of their appointment?
But they were not appointed as a regular employee.
They were appointed pursuant to an advertisement.
Not so far as question number 3, 5 and 7, because there is statement by them at corrective, and the appointment letter is also there. It is an executive. In that executive, the name of the person number 3, 5 and 7 is there. That they were appointed pursuant to the advertisement.
It's there?
Yes, executive 2 at page 4. Page 41.
Page 40?
41.
Okay, annexure 2, page 41.
Yes, and the corresponding paragraph is para 10, wherein they have said para 10 of the repetition.
Yes.
Yes. The petitioner humbly submit that the settlement officer Gurukha has appointed pursuant to the advertisement on the post of Sakai Mare after conducting written examination on 17/5/2001. The settlement officer has selected 50 candidates and name of the person of 5 stands at serial number 9, name of person number 7 stands at serial number 10, name of person number 3 stands as serial number 26 of the appointment letter number so and so, which is an exact name at page 41.
And what about rest?
Rest not in the next paragraph, not they say that they have been working since 1990.
But there is no statement that they have been working, they were selected pursuant to any act.
In the supplementary affidavit subsequently they say that they have been working. But no appointment letter. But they have been working. Because it is evident from our chart.
From your chart, do you admit that they were selected pursuant to advertisement?
No, with respect to it's number 3, 5 and 7 we admit that they were appointed pursuant to the advertisement. So far as the others not, they say that they have been working.
If they were appointed pursuant to advertisement, there is a question of their regularization and there is a question of their rejection.
In the appointment letter itself, it has been stipulated that they will not claim for regularization. That is in that stipulation. Page 41. Page 41. Third paragraph of the top. सफाई मौलिक के रूप में कार्य करने वाले व्यक्ति किसी प्रकार के स्थायी अथवा दैनिक वेतन भोगी होने का दावा नहीं करेंगे। सफाई मौलिक के रूप में कार्य करने को उन्हें सरकार द्वारा निर्धारित उजरत दर का भुगतान किया जाएगा। कार्य के लिए बनाए जाने में किसी प्रकार का भत्ता देनी होगा। और
that is why they were to be recognized. Now, ultimately, you say that there is no sanction.
There is no sanction. And they have relied upon the judgment of the Nihal Singh's case that they have brought in the disorder. But with respect to Nihal Singh's case, in the earlier round of litigation, when the minor was supposed to file the order against them, there is a comment, there is a finding with respect to it. Though the state has the power to sanction the post, but simply because they have been working on that post for a long period of time, that does not entitle them to the. That is the finding in the light of the Nihal Singh. May I please refer to that paragraph of my judgment. This is judgment dated 8th of February 2024 and the relevant paragraph where my has considered the judgment being relied upon is para 25.
Where do I find this?
Finding in the order statement. This is dated 8th of February 2024.
8 February 24.
Yes. This is and the relevant paragraph is para 25 at page 10.
This is the same judgment which has now been set aside. We are not going to recognize.
Just only since it has got a persuasive effect, I'm not saying it's finding. Since it's persuasive and malus
I will not
finding in this.
But it is para 20.
Para 25, sub para B. In the next page. So far as the judgment passed by the Honorable Supreme Court in the case of Nihal Singh is concerned, para 20 of the state judgment is quoted as under. But we do not see any justification for the state to take a defense that after permitting the utilization of the service of a large number of people like the appellants for the decades to say that there are no sanctioned posts to absorb the appellants, sanctioned posts do not fall from heaven. The state has to create them for a conscious choice on the basis of some rational assessment of the need. The said judgment simply states that it is for the state to create the sanctioned post. The said judgment does not indicate that clearly because person continue to work, they are automatically entitled to regulation without any sanction. The said judgment would not entitle the petitioners to claim relief from this court as prayed for in the litigation, particularly when in case of so and so appropriate action to frame the policy as well. But this stand has been taken in the counter affidavit also by the state. We have taken this stand. This is our stand because the matter was remanded only on the ground that there was no counter by the state. There is no adverse finding with respect to the finding given by this honorable, by the division. But we have taken this stand in the counter affidavit. Please place that portion of the counter affidavit. In the supplementary counter affidavit pursuant to my last order, on the last order, that is dated 6th of February 2026, However, there are two issues. May I please place the order dated 6th of February 2026.
Yes.
Sigma. The supplementary counter approved by the state should also indicate as to why an appropriate order in terms of the judgment passed by the Honorable Supreme Court, which has been referred to in the rejoinder, be not passed, considering the fact that the petitioners have claimed to have been working continuously since 1992-97 and without any complaint, and the requirement of work is of a permanent nature. And the supplementary affidavit should also indicate as to whether treatment of the petitioner on daily wage basis at 250 per day for long year amounts to exploitation. Plus, we have responded to this issue in the supplementary counter affidavit dated 2005 yesterday. Yes. Para 4 we have discussed the Mallard's order has been quoted wherein both the issues have been segregated, and para 8 the response is there. Response to the first issue, why an appropriate order in terms of the judgment passed by the Honorable Supreme Court, which has been referred to in the rejoinder, did not pass, considering the fact that the petitioner have claimed to have been working continuously since 1997 and why without any complaint, and the requirement of work is of permanent nature. First, the petitioner at para 8 of his rejoinder dated 8/1/2026 has referred to para 20 of the judgment of the Honorable Supreme Court in case of Nihar Singh, that in this regard, the answering response relies upon para 25B of the judgment dated 8/2024 passed by this Honorable Court in India. For the reason that the order dated 20th of March 2025 passed in LPA number so the order dated 8/24 passed in the case in hand was set aside without expressing any opinion on the finding given in the order dated 8/2024 passed in so and the matter was simply remitted to this Honorable Court for fresh consideration and disposal after the filing of the counter appeal of this court. That it is strictly stated in summary. The said judgment passed by the Honorable Supreme Court in the case of Nihar Singh and others states that it is for the state to create the sanction code. The said judgment does not indicate that merely because the persons continue to work, they are automatically entitled to regulation without any sanction code. The said judgment would not entitle the person to claim the reliefs from this Honorable Court. That it is further submitted that no right crystallized on the petitioner to claim the regulation when they are not covered under the existing scheme of regulation of the state. Remember, this is not for the first time they are coming before this Honorable Court for the purpose of regulation. This is the third round of litigation. So the finding given in the earlier two round of litigation by this Honorable Court is quite relevant because in the light of the findings and in the light of the direction passed to those two judgments, the impugn order has been passed. Because there the stand of the petitioners was that they may be regularized under the scheme.
Yes, once
They have been
once they said that they should be regularized under the scheme.
Yes.
According to you, they cannot be considered under the scheme because there is no sanction.
No sanction.
That is the reason we are
Yes.
saying. So far as delay is concerned, that is absolutely irrelevant. There is actually no delay. Right?
I am not pressing on it.
Let's forget about it.
Yeah.
So, in absence of sanction post, that scheme does not apply to them.
Because it is not their case that they are covered under this scheme. It is they are simply claiming on the basis of long duration.
Long duration, but they have challenged that order also.
Yeah.
And which are those two orders?
Yes, they are in Excel 3. Sorry.
The rate was fixed pursuant to a circular.
Pursuant to the
That circular they challenged.
they challenged the earlier number.
Yes. They challenged the circular except petition number 4 and 8. They
But,
4 and 8 did not challenge it.
And Excel 4 and Excel 5. In Excel 4 at page 55.
Yes.
This is WPS number 1226 of 2008, dated 11th of September 2017. The relevant paragraphs are 6, 6 at page 57.
Yes. They earlier knocked the door of the. First, they filed WPS number 6773 of 2004. Right?
Madam.
Then they filed WPS 1226 of 2008. Once they filed it through association. Right?
Madam.
Then they filed another petition WPS 462 of 2005, 2015, where they challenged this
circular.
wages. And then so there was a direction to consider their claim in terms of the notification.
That's
Dated
why
13 to 2015.
since they were direction law, they were considered no subsequently
In terms of the notification.
in terms of
And according to you, they are not covered by the notification. And even they do not dispute that they are not covered by the notification.
yes, because they
It is not their case that they are covered by the notification. They are claiming regularization irrespective of that.
irrespective of the notice simply on the basis that they have been working since. And the nature of work, Lord Manu wanted to know what is the nature of
But
work.
in the case of Dharam Singh case, paragraph
No, Mr. Mishra, I am asking you time and again. Do you say that you are covered by the scheme or not? If you say you are covered by the scheme, I will examine your case in terms of the scheme. If you say that you are not covered by the scheme, I will examine your case from the terms of regular jurisprudence of regularization. Do you say that you are covered by the scheme? And if you say, place the scheme and then show us that you are covered by the scheme. Then straight away we will hold that you are covered by the scheme and you are entitled for regularization. Yes?
earlier judgment also,
Earlier judgment आप भूल जाइए, हम उसको नहीं देखेंगे. Why should I see the earlier judgment?
the earlier judgment is placed there.
उनके प्लेस करने से कुछ नहीं होगा. हम earlier judgment को रेफर करके कुछ नहीं करेंगे. उन्होंने earlier judgment जो counter affidavit में जो observation है उसके लिए
Findings earlier judgment में भी यही था.
earlier judgment has been set aside. Please इसमें कोई finding में मत जाइए. हम आपसे आपका case पूछ रहे हैं, Mr. Mishra. I'm absolutely with open mind. I'm asking your case. Do you say that you are covered by this scheme of regularization or not? If you say yes, I will examine the scheme and then find out whether you are covered by the scheme or not.
But in the
Is it your case that you were working as contractual employee against sanctioned post? Or yes or no?
in view of the advertisement, it apparent clear that
Pleading दिखाइए.
huh?
Pleading दिखाइए that you were working against a sanctioned vacant post. मिस्टर मिश्रा, आप हमको सिर्फ इतना सा बता दीजिए. आप इस बात को आंसर करना चाहते हैं कि नहीं करना? That you are covered by the scheme or you are not covered by the scheme. I am not telling you that you should accept it or reject it. I am just simply asking you. Do you say that you are covered by the scheme?
Paragraph 7 में हम लिखे हैं petitions on this they were appointed as a supply Mori Ganga after following the procedure at the roster clearance advertisement and working season. The nature of the work.
आप मेरे बात का जवाब भी नहीं दे रहे. नहीं जवाब दीजिएगा तो हम एडमिट करके छोड़ देंगे. आपने डिसाइड होते रहेगा जब. If you are not responding to my question, आपसे एक ही चीज हम बार बार पूछ रहे हैं. Is it your case that you are covered by the scheme? You don't want to answer. यही लिख के हम एडमिट करते हैं, फिर अपने आराम से सोचिएगा, समझिएगा आपको क्या स्टैंड लेना है, एंड देन यू टेक योर स्टैंड. यू कांट इग्नोर एन आंसर लाइक दिस. 10 बार आपसे एक ही सवाल पूछ चुके, 10 times.
Again, the sanction post मतलब sanction post.
नहीं, ये सवाल नहीं. हम सब आपसे ये जानना चाहते हैं, are you claiming regularization in terms of the scheme? Yes or no?
Yes.
Then show me the scheme and say that you are covered by the scheme. Where is the scheme? Scheme तो होगा ना, आप तो you are referring for regularization rules of 2015.
हाँ, 15 में
कहाँ है वो?
No, that is not on. The relevant rule is 3 cut 2. That is on page 2. यदि किसी कर्मी द्वारा भारित पद स्वीकृत न हो, तो निर्धारित सेक्शन की योग्यता पूरी नहीं करता हो, तो कालांतर में भारित पद स्वीकृत होने एवं प्रधारक द्वारा निर्धारित सेक्शन की योग्यता प्राप्त करने की स्थिति में भी उसका सेवा निलंबितीकरण पर विचार नहीं.
The clause is not under challenge.
submission and the episode. That is a recent judgment that when the post is not sanctioned. That in the case of Dharam Singh that I have already given my earlier occasion. Paragraph 40. Paragraph 40. The learned single judge of the High Court also declined relief on stating that the petitioner had not specifically assumed the subsequent decision. It is such and such, however, in view of overlooked that the petition is squarely challenged. 11/99 refusal as the High Court itself directed a fresh decision during pendency, and later rejection was placed on record by the respondent. In such circumstances, we believe that the High Court was obliged to examine the legality of the state's stance in refusing sanction, whether in 1999 or upon reconsideration in 2003, rather than dispose of the matter on the mere technicality. The division bench of the High Court compounded the error by affirming the dismissal without engaging with the principal challenge or intervening material. The approach of both the courts in reducing the dispute to a mechanical inquiry about rule and vacancy, while including the core question of arbitrariness in the state refusal to sanction post despite perennial need and long service cannot be sustained. But my case before your lordship that this petitioner have been rendering service since from 93
You read
onwards.
para 4.4 of the judgment that you have cited.
4.4. 24/10/1991 the commission resolved to
No. Aggrieved. The appellants instituted the
institution read petition number such and such before the High Court being passing the state's order dated such and such a maintenance to the state to sanction create 14 post commission in term of commission resolution and proposal and thereafter to regularize the appellant against those posts with regular pay.
आगे पढ़ो.
Consequential non-interference and salary direction. On 24/4/2002, the High Court directed the Commission to send a fresh recommendation for sanction of appropriate Group D post and directed the state to take fresh decision thereon. In the meantime, having regard to the appellant long engagement, the Commission was directed to pay them the minimum of the applicable pay scale. Pursuant thereto, a fresh recommendation was sent and by communication dated 25/11/2003, the state declined sanction against citing financial ground and a ban on creation of new posts. By judgment dated such and such, Learned Single Judge of the High Court dismissed the petition holding that no rule for regularization in the Commission had been shown and that even assuming the 1998 regularization rule applied, there were no vacancies for appellant. Moreover, the single judge held that the regularization was impermissible in view of the law declared in Secretary of State of Karnataka versus Umadevi and allied proceeding. It was also observed that the petitioner appellant herein had not specifically assessed the subsequent decision dated such and such. The appellant preferred specially petition so ensured by the ensuing judgment. The division bench of the High Court affirming the dismissal, observing that the appellant were duly deliberated and there were no rule for regularization in Commission and no vacancy exists for considering that. Agreed by the order of the division bench of the High Court, the appellant had approved this court in the present appeal. The question before us is whether the High Court erred in filing to adjudicate the appellant's principal challenge to the state refusal to post sanction
therefore-
and
So therefore, there was a decision of the state. There was a decision of the state that they will not sanction fresh post. Correct? Which was under challenge before the Honorable Supreme Court. So the Honorable Supreme Court said that the court has not taken a correct approach by dismissing the writ petition because that decision was subject matter of scrutiny before the High Court. So in this particular case, initially, first prayer is that you are entitled under the scheme and therefore you should be regularized. If you are entitled under the scheme, then you have to show that the post was sanctioned, right? And you were working against a vacant time sanctioned post. They have rejected your case on the ground that there was no sanctioned post available. Correct? And you have also made a further prayer of regularization, but there is no prayer, and even if we under 226 ask them to consider the case for sanction of post, that a mandamus can be issued only when you accept that there is no sanctioned post. If you say that you were working against sanctioned post, then we have no option but to ask them to regularize you because you were working against a sanctioned post. So that is why I am asking you repeatedly that if the decision is incorrect on the ground that you were working against sanctioned post, then the decision has to be set aside simply. But you have not made out a case that you were working against a sanctioned post. Right? In this judgment which you are relying, there was already a direction to the state to sanction the post, to consider regarding sanction of post. I can also pass the same order for the state to consider regarding sanction of post. They will consider. क्या चीज? This is the judgment which you have cited. Which is the other judgment you have cited? भोलानाथ. भोलानाथ में क्या बताइए? What is भोलानाथ? You see 14, para 14. The respondent state was not justified in continuing the appellants on sanctioned vacant post for over a decade. Under the nomenclature of contractual engagement and thereby denying them consideration for regularization. आप बताइए, if you were appointed against vacant sanction post, then I'll pass the same order. एकदम same order आपको, same to same.
So next week,
नहीं, next week में नहीं रखेंगे, आज full stop.
those of the part-
नहीं, 1-1.5 घंटा से आपको सुन रहे हैं.
नहीं हमको कहाँ सुना?
Yes.
यही लोग
नहीं,
time-
नहीं,
I have
हम
never
इसकी-
taken time.
What do you mean?
I have never taken time.
No, there is no question of grant of time. I'm asking you. You tell me what is your case. Have you been working against vacant sanction post on contractual basis? That is not your case. If that is your case, please show it.
I have shown all the document whatever we petition. That very process सोचने के लिए एक बार बस
नहीं, हो गया बस. उसका time कुछ नहीं.
उसमें तो ये भी है कि लंबा समय से कर रहे हैं तो स्टेट हैज टू क्रिएट दी इवेंट पोस्ट इन
You have to wait. Die or buy दोनों simultaneously कैसे लीजिएगा?
ये डिनाई नहीं
Either you say that you are covered by the regularization scheme, or you say you are not covered, still you are entitled for regularization because you are working for so long. You can't have both, no? Right and left both. कैसे? You have to give up. If you say that you are covered by the scheme, then you don't need more mercy from the court. That is your right.
but he has rejected that the post is not sanctioned. Then how can I say madam that post is sanctioned? Only I
If you are not in a position to say that the post was sanctioned, then your first relief is infructuous. Because as per the scheme, they cannot regularize you unless the post is sanctioned. Isn't it? Right? They cannot regularize you unless the post is sanctioned.
इसमें तो पोस्ट अगर सैंक्शन नहीं है लंबा समय से काम कर रहे हैं तो पोस्ट सैंक्शन नहीं करेंगे नेचर ऑफ वर्क की
वो तो हम बोल रहे हैं, हम दे रहे हैं इनको डायरेक्शन कंसिडर करने के लिए कि पोस्ट सैंक्शन करें.
हाँ
कंसिडर करेंगे अपना पोस्ट सैंक्शन करने के लिए बिकॉज यू आर वर्किंग फॉर सो लॉन्ग.
हाँ मुझे ऐसा है कि जो काम हम कर रहे हैं सेटलमेंट ऑफिस का काम कर रहे हैं मान लो पहले बोले थे कि जो रेंट रेवेन्यू का रिकॉर्ड बनाना कितना इम्पोर्टेंट वर्क है और इस तरह से काम हो रहा है सच रियल नेचर ऑफ वर्क में काइंडली कंसीडर एंड एप्रोप्रिएट डायरेक्शन में भी स्टेट द नीड्स एंड कितना दिन से काम कर रहा है सर 30 साल तो काम ही हो गया ये भी तो मान रहे हैं कि एडवर्टाइजमेंट अप्लाई है सब कुछ हो रहा है
Are there any sanctioned post of this nature?
No. Of this nature. no.
Mohiliya?
Remember, there are 6 settlement offices all over the Jharkhand. They are from Dumka. In Dumka and all other places, there is no such thing. And the post number 8.
And you ask them to work on
पूरा
contract
संस्था
basis
बनना का वही है
for years together.
वही काम होता है सर
And they are dealing with the important land records. So it's a perpetual work.
We have been taking work from.
Perpetual work?
Yes. The only constraint is that it is our regularization rules which says that this sanction is supposed to be there for the participants. They are not covered. It's not that their case was not considered. They were considered, it was found that they were not. And but there is no prayer, but my learned friend was referring to the judgment of Dharampalgarh, wherein there was one of the prayer was to create the sanction. There is no such prayer in this case. That first sanction the post, then regularize. They are simply saying that they may regularize.
They are involved in preparation of land reports.
There.
Not to be said at a settlement.
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the claim for regularization of the petitioners has been rejected by the impugned order dated 6/4/2023 by observing that the post on which the petitioners were seeking regularization is not sanctioned, and therefore they are not entitled for regularization under regularization rules of 2015 within bracket amended bracket closed rules 3 within bracket KJ bracket closed Roman 2. He has also submitted that additional reason has been given by stating that the claim for regularization was not made within time. However, from the perusal of the, however, he has placed the documents on record to submit that the recommendation for regularization was made time and again. To the second point, the learned counsel for the state has submitted that the same may not be relevant. What is relevant is that there is no sanctioned post of Mohidiyar in which the petitioners were working on daily wage basis. It is the specific case of the petitioners in paragraph 6 that the petitioners were working on the post of Mohidiyar on contractual basis as daily wager, as Safai Mohidiyar in settlement office Dumka. He submits that in absence of sanctioned post, the scheme of regularization is not applicable, and therefore the impugned order dated 6/4/2023 does not call for any interference. The scheme of regularization has been placed on record by the learned counsel for the state. To this, the learned counsel for the petitioners has submitted that the learned counsel for the state has also submitted that this is practically the fourth round of litigation. And one such litigation was filed by their association also. उसमें दिया हुआ है.
हाँ दी.
He submits that their remuneration was fixed by a circular, and that circular was also challenged. And ultimately, there was a direction issued by this court to consider the case in terms of the scheme for regularization, which led to passing of the interim order dated 6/4/2023 after examining this aspect of the matter. And since they were not entitled for regularization in terms of the scheme, the claim for regularization has been declined by observing that the posts in which the petitioners are seeking regularization are not sanctioned posts. During the course of hearing, it transpired that the work which is being undertaken by the petitioner are of perpetual nature, and they are engaged in preparation of the land records with respect to settlement office of Santhal Pargana division at Dumka. It is further not in dispute on the basis of materials on record that the petitioners have been continuously working for 20 years and are being paid remuneration as fixed by the circular of the state government. Given the aforesaid facts, the learned counsel for the petitioners has submitted that it is a fit case where the state should be directed to create posts for such essential work of the state which relates to creation of land, preparation of land records. And the very fact that petitioners have been working since more than 20 years reveals that the work is of perpetual nature. The learned counsel submits that the action of the state in not creating such posts and using the services of the petitioner on contractual basis or making payment on the basis of circular issued from time to time amounts to their exploitation. They have spent their whole material life serving the state while preparation of land records. He submits that under such circumstances, irrespective of the claim of the petitioner seeking regularization under the rules of 2015, appropriate direction be issued upon the state to create posts and consider the case of the petitioners for regularization. He has also submitted that so far as petitioner numbers 5, 7 and 3 are concerned, they had participated in the selection process pursuant to the advertisement, and their appointment letters and the memo by which they were selected has also been placed on record. And so far as petition number 1 to 4 are concerned, 1, 2 and 4.
6 and 8 is also.
6 and 8.
Next to
Ah,
that.
okay.
Yes.
So far as 1, 2 and 4 are concerned, so far as petition number 1, 2, 4, 6, 8, 3 and 5 are concerned, specific statement has been made in paragraph 11 giving the period for which they were working. He submits that they were being paid as per the circular, which is apparent from the documents placed on record. Paragraph 10 and 11 of the petition is quoted as under. To this, the learned counsel for the respondents has submitted that there is no prayer in the petition seeking a mandamus upon the state for creation of post and regularize the petitioners against such post, and therefore no such relief be granted to the petitioners in this petition. He has further referred to the Annexure 2, which relates to the appointment of petitioner number 5, 7 and 3. Their name appearing at serial number 9, 10 and 26. To submit that at the time of appointment itself, it was stipulated that these petitioners would not claim any regularization nor will claim any payment on daily wages. Rather, they will be paid on the basis of the circular issued by the state government from time to time. He submits that the petitioners have accepted their appointment in terms of the payment to be made by the circulars issued by the government from time to time. Therefore, otherwise also the petitioners are not entitled to any relief. The learned counsel has also submitted that the earlier order passed by this court was set aside by the LPA court merely on the ground that no counter affidavit was called for by the state. He has submitted that now the counter affidavit has been filed and the state has opposed the prayer of the petitioners. He has also submitted that that is all. The learned counsel for the petitioners in response has relied upon the judgment passed by the Honorable Supreme Court reported in 2025 SSC Online 1735, Dharam Singh versus State of UP, and has referred to paragraph 14 thereof. However, which is quoted as under, however, from the facts in the said case as mentioned in paragraph 4 of 4.4, it appears that earlier a mandamus was issued to the state to sanction / create certain posts in terms of commission's resolution and proposals, and thereafter to regularize the appellants of the said case against those posts with regular pay. He has also relied upon the judgment passed by Honorable Supreme Court in 2026 SCC Online SC 129, Bhola Nath versus State of Jharkhand, and has referred to paragraph 14 of the said judgment, 13 and 14 of the said judgment, wherein he submits that it has been held that mere contractual nomenclature of the appellant's engagement in the said case does not denude them of constitutional protection. He submits that it has been observed by the Honorable Supreme Court that the state, having availed the appellant service on sanctioned post for over a decade pursuant to due process of selection, and having consistently acknowledged their satisfactory performance, cannot, in absence of a cogent reason or speaking decision, abruptly discontinue such engagement by taking refuge behind formal contractual clauses. He submits that ultimately it has been held that the respondent state in the said case was not justified in continuing the appellants of the case on sanctioned vacant post for over a decade under the nomenclature of contractual engagement, and thereby denying them consideration for regularization. He has also relied upon the judgment passed by the Honorable Supreme Court. वो कौन सा है judgment? जिसके हम लोग Nihal Singh versus Union of India, Nihal Singh and others versus State of Punjab, reported in bracket 2013-14 SCC 65, to submit that it has been held in paragraph 20 of the said judgment that there can be no justification for the state to take a defense that after permitting the utilization to the services of large number of people like the appellants of the said case for decades, to say that there was no sanctioned post to absorb them. He submits that it has further been observed that the sanctioned posts do not come from heaven, and the state has to create them by a conscious choice on the basis of rational assessment of the need. The learned counsel submits that once there is a continuous requirement of Muhurias, and the state having taken the work from the petitioners for years together, they cannot deny regularization to the petitioner merely on the ground that there are no sanctioned posts. He submits that appropriate orders be passed so that the state sanction the post and consider the regularization of the petitioner on such sanctioned post. He submits that such important work of the state regarding maintaining of land records should not be left upon the persons who are not regular employees of the state. Okay? Then continue. नहीं रिजर्व कर दीजिए, फाइनल ऑर्डर लिखा है खानों को लिखाना पड़ेगा, इन लोगों का सबमिशन लिखा है, देखते हैं क्या दे सकते हैं इनको।
Okay.
Orders, item 2, CMP 688 of 2025.
Your Lordship, as per the last order, we have filed the requirements of notice. As per the report, Your Lordship, it has been validly served.
The return unserved. From where are you saying that it has been validly served? From where are you saying that it has been validly served?
Apologies, Your Lordship, my junior.
तो जूनियर को भी तो बुलाइए।
Not checked for pardon.
क्या बोलते रिटर्न हुआ? इसमें ना आपको कुछ amendment फाइल करना है, because earlier the secretary was somebody else, maybe that he has left it.
Of the different
I
boss.
am not your advisor, please. तो आपको कुछ पता
He
ही
is
नहीं
still
है.
the
He is still the secretary. CAP number 688 of 2025. The learned counsel for the petitioner submits that, as per office note, the notice upon sole of fee has returned unserved, and in the unserved envelope it has been mentioned that the addressee has left. The learned counsel submits that the opposite party is an institution, namely Shri Shri Goshala, Dhumka, and in the memo of petition he is being represented by the secretary. He prays for and is granted weeks time to take fresh steps for service of notice upon sole opposite party through ordinary process. क्या पता ये सेक्रेटरी नहीं भी होंगे अब?
Lordship is still there in Luka. He is a practicing advocate and also the secretary of this Sri Sri was.
Dusty in addition. The recusals will be filed within 2 weeks. The service of the affidavit regarding Dusty service of notice will be filed within 4 weeks. There. वो विटनेस के प्रेजेंस में करा लेंगे साइन. Post on 31st July.
Item 3, CMP 1105 of 2025.
Yes.
Do you have objection to this IA?
Higher documentation. CMP number 1105 of 2025. Counsel for the respondents pray for time to respond to IA number 6164 of 2026. Post on 3rd of July. July.
Item 4, CMP 1108/2025.
This IE number 1318 is for a substituted service of notice upon respondent number 2 and 3. Whereas respondent number 1 and 4 have appealed.
IE number 1318/26, LCAB number 1108/25. The learned counsel for the petitioner submits that this petition has been filed for substituted service of notice upon respondent number
2 and 3.
2 and 3, who could not be served in spite of best of their effort. She also submits that the last known address of respondent number 2 and 3 is in the district of East Sindhu, within the state of Jharkhand. Considering the submissions, let notice there is a limitation also in this.
Yes, Your Lordship, there is a CMP as well as a limitation. Notice.
Notice with respect to IE number 3177 of 2025 seeking condemnation of delay of 113 days, and notice with respect to the CMP number 1108 of 2025 we published in the newspaper Prabhat Khabar and Telegraph having circulation in district of Sindhu East. Sindhu East, है ना?
हाँ, जोशी.
The format of notice, the proposed format of notice be furnished by the petitioner in the registry within 2 weeks from today. The registry is directed to hand over the notice to be published in the newspaper to the petitioner within 2 weeks thereafter. The supplementary affidavit annexing the original newspaper publication be filed before this court by 7th of August. उसमें लिखिएगा fixing the date of appearance on 31st of June. Post on नहीं ऐसे नहीं होगा. Fixing the date of appearance में post on 7th of August.
Item 5, CMP
I
1152
disposed of.
of 2025.
Yes. CAP number 1152 of 2025. Issue notice to the respondents to the opposite parties. Respondents होगा? Opposite parties. Only state is there. You are for the state. Where is the petitioner? Restored by the nobody appears on behalf of the petitioner. The learned counsel for the state is present. The learned counsel for the state has submitted that there are no serious objection with respect to restoration of first appeal and also for condonation of delay of 117 days. To which a petition for condonation of delay has been filed through IA number 16087 of 2025. After hearing the learned counsel for the respondents and having gone through the interlocutory application and being satisfied with the cause shown, the delay in filing the petition seeking restoration of first appeal is hereby complete. IALA. Mail CMP number 1152 of 2025. This petition has been filed for restoration of first appeal number 260 of 2023, which was dismissed on 26/3/25 on account of non-removal of defects in terms of 27/2/2025. Being satisfied with the cause shown. Sir, last order कहाँ है? DCS का केस डिसमिस हुआ था? That's right. Being satisfied with the cause shown, the time granted while order dated 27/2/2025 in first appeal number 260 of 2023 for removal of defects is extended till 19th of June. The office is directed to forward a copy of this order to the learned counsel appearing on the learned counsel for the petition. CMP disposal.
Item 6, CRMP 3610 of 2025.
Petition seeks adjournment. Post on 19th June.
Item 7, CIP 51 of 2026.
Why didn't you comply the order? यहाँ पे हम इसी के लिए बैठे हैं restoration square. Yes. Why didn't you comply the order? एक बार restoration होने के बाद फिर DFD. So, मिल गया? अब मिल गया है? बिना कॉस्ट के रेस्टोर नहीं करेंगे। बिना कॉस्ट के रेस्टोर नहीं करेंगे। Okay, there is a limit to which you have undertaken to remove the defects.
Earlier, there was CMP model that was filed for restoration of the
That's right. This is
The
CMP.
extension was given by lordship, and due to that, my lord face was not received my lord in time. So that
This petition has been filed for restoration of CMP number 935 of 2024, which has been dismissed on 17/1/2025 on account of non-compliance of the entry order dated 6/12/2024. The learned counsel for the petition has submitted that the CMP number 935 of 24 was filed for restoration of WPS number 4284 of 2023, which in turn was earlier rejected on 18/6/2024 on account of non-compliance of pre-entry order dated 17/5/2024. He has submitted that in spite of best of efforts, the order passed in CMP number 935 of 2024 with respect to removal of defects in the writ petition would not be complied. तो learned आपको क्या बोलना है? Sorry?
The DOT was done in the year 2025 of the month of January.
The learned counsel for the state has opposed the prayer and has submitted that the order of CMP was passed on 6/12/24, and after more than a year, after about a year, the restoration application has been filed. After hearing the learned, to this counsel for the petitioner submits that if the CMP is not restored, the writ petitioners would suffer irreparable loss and injury, who are in total 49 in number. After hearing the learned counsel for the parties, this court finds that in spite of repeated opportunities, the defect in the writ petition, being the WPS number 4284 of 2023, has not been removed, and even the however, considering the aforesaid facts and circumstances, the time for removal of defect in WPS number 4284 of 2023 is extended till 19th of June, subject to payment of cost of ₹10,000 in the Advocate Home Clerks Association. The receipt regarding payment of cost should be filed in this case latest by 12th of June, failing which the writ petition shall not be restored. If the cost is deposited and the defect in the writ petition are removed by 19th of June, the office is directed to place the writ petition before appropriate date as per
one I
limitation.
one I.
Writ में limitation कौन सा limitation? CMC अच्छा. IA number 1593 of 2025. There is a delay of 265 days in filing the application for restoration of the CMP. The learned counsel has referred to paragraph 8 of the interlocutory application. considering the government's delays.
Item 8 CMP 76 of 2026.
Sorry?
Simple restoration.
इसका restoration है second appeal 91
Yes, but you're not saying, there is you not saying what
कहाँ
Yes, it is not his restoration. And he, there are 10 of you not saying what He was appearing on that day, he's saying that I have no instruction to argue the case. And the suit is of 1960, partisan suit.
Not going to merit, my lord.
Merit पर ही
Orders में आया
it has already been dismissed against respondent number 2.
नहीं ये तो
Yes.
चलेगा this is not
And there is another appeal arising out of the same judgment has already been abated.
उसमें CMP डाउन
बहुत
Just,
अच्छा बात है,
just to
उसको भी
linger the
dismiss कर
matter.
देते
नो नो my lord.
उसको भी dismiss कर देते
Yes, just to linger the matter.
See, you appeared, you were not ready to argue, you do not want to do anything, you have no instructions, this is not going to be restored. There is no question of restoration.
Actually, my lord,
आप हमको सिर्फ इतना बता दीजिए, उस समय आपको, just a moment, उस समय आपके पास इंस्ट्रक्शन नहीं था। ये वाला केस कैसे विदाउट इंस्ट्रक्शन, विदाउट वकालतनामा फाइल कर दिए?
actually, my lord, orders में आया हुआ था, my lord. Orders में आया हुआ था कि एक प्रेम्पटिव ऑर्डर का कंप्लायंस नहीं हुआ था। एक रिस्पोंडेंट मर गए थे, my lord, उनके बिहाफ में इंस्ट्रक्शन नहीं था कि उसके लिए दूसरे केस में फाइल हो चुका था। तो
This is not a case for restoration. The case has been dismissed on merits. For non-prosecution बोले, but there are so many things which have been mentioned.
नोटिस हुआ था, my lord, तो उसमें नोटिस के बाद वैलिड सर्विस हो गया 1 to 12 को और 9 और 25 टर्म हो गया है to do that this case में।
You say that you have no instructions. So fresh वकालतनामा फाइल करिए। सबका वकालतनामा fresh फाइल करिए। हम ऐसा सुनेंगे नहीं। I will not listen to without fresh वकालतनामा. You have to file वकालतनामा in this case. उसके बाद सोचेंगे क्या करना।
One more fact, my lord. They have, my lord, even the lower court record, they have, my lord, what happened, they have done everything. It is not available for execution till date. The plaintiff is roaming from 1960s, my lord. This is the situation in this case. 1960 का पार्टीशन सूट का ये 25-60 साल तक ये लिंगर करते रहे।
मेरा पार्ट से कोई लिंक कर
आप ही के पार्ट से लिंगर और लोअर कोर्ट का रिकॉर्ड को भी डिस्प्लेस करा दिए हैं। They are acting in as it is not a simple case of restoration that I am saying.
1 लाख से कम तो कॉस्ट करेंगे ही, नॉट लेस देन 1 लाख, नॉट अ पेनी लेस देन 1 लाख। कोई बात नहीं, रेस्टोरेशन के लिए तो 1 लाख रुपए तो देना ही पड़ेगा। 1960 का सूट आप रेस्टोर कराना चाहते हैं, पहले तो आप वकालतनामा फाइल करिए, तो हम सुनेंगे नहीं। यू हैव नो इंस्ट्रक्शंस, so therefore you have no instructions to file this CMP also. खाली सिम्प्लिसिटर एजेंट करेंगे हम, आपका ये वकालतनामा इसके बिना सुन नहीं पाते, और लिमिटेशन भी लगा दी है इसमें, बहुत अच्छी बात। सब जीवित हैं, ऑल द पीपल आर अलाइव, विल यू अंडरटेक? आधे लोग मर गए होंगे इसमें से।
दो ही आदमी मरे हैं मैडम, तो रिपोर्ट में काइंडली मेक द सेम मैडम।
ये जितने भी रेस्पोंडेंट्स हैं 26, 29, ये सारे के सारे 1991 से सब जीवित हैं।
The original plaintiff died, her sons died. Now the third generation and the fourth generation are before you.
पहले आप वकालतनामा फाइल करिए, उसके बाद सोचेंगे। CMP नंबर 76 of 2026, also for the petition 6 adjournment. Post on 31st July. सबका आधार के साथ फाइल करिएगा, देन आई विल सी। तो फॉर्मा भी है इनके,
वो भी इनके सपोर्टिंग में है, जो कुछ लोग तो एग्री नहीं किए सेकंड अपील में। Now
तो
just to linger the matter, they are
1960 का सूट तो हम नहीं ले
partition. And there, Lord, the situation is that now I have filed a petition, Lord, for the constitution of all the documents from here, Lord, because they are, what is not granting the lower court degree, Lord, here, the LCR, because it is not available, they have misplaced that. Now,
यहाँ रिकॉर्ड नहीं आया था,
record में वो आ गया कि वो misplace हो गया।
डिक्री।
Yes, this is the situation.
तो इन्होंने तो अपने अपील में डिक्री फाइल किया होगा ना,
ये उसी से उससे सर्टिफाइड कॉपी हमको मिल नहीं रहा है। Now I have to file petition for that.
नहीं, आपको इनका मेमो ऑफ अपील का पूरा का सर्टिफाइड कॉपी ले लीजिए, वो तो उसके साथ ही मिलेगा ना आपको।
that I am trying.
इनका मेमो ऑफ अपील का सर्टिफाइड कॉपी ले लीजिए, तो उसके साथ आपको सारा इलेक्शन में मिल जाएगा।
Because the record is pending before this court, therefore I was not getting all those.
You better take the certified copy.
Yes, of the entire second appeal.
Entire second appeal का
Yes.
ले लीजिए, पूरा रिकॉर्ड का ले लीजिए।
Item 9 CMP 162 of 2026.
Restoration matter 3 IU for substitution of respondent number 1, 8 and 10. Pay for restoration of SC number 338 of 2016, which has been DOT for non-prosecution on dated 4/3/2025.
Who is your senior?
मैम इसमें लॉट्स में हम ही है इसमें।
ये हम रेस्टोर नहीं करेंगे।
भैया फेस वकालतनामा फाइल हुआ
नहीं,
है।
आपका फ्रेश वकालतनामा से क्या मतलब है?
ये
सेकेंड राउंड ऑफ रेस्टोरेशन इन सेकेंड अपील, मजाक बना के रख दिए क्या हाईकोर्ट का?
और सिर्फ ये जो पहले जो है इसमें लैंडेड काउंसिल थे हेल्थ इशू की काइंड अपीयर नहीं हो पाए थे, इसलिए अपीलेंट ने दूसरे एडवोकेट चेंज किया है।
वेरी गुड, यू कीप ऑन चेंजिंग एडवोकेट।
लॉर्डशिप लास्ट चांस दे रही है।
नहीं, कोई लास्ट चांस
अपीलेंट डेली आते हैं लॉर्डशिप के बोलते करवा देंगे।
पहले भी एक बार
यस 19 में हुआ था।
19
तो एडवोकेट इसलिए चेंज किए थे, वो अपील नहीं हो पाए थे।
19 में आपका एक बार डीएफडी हो चुका है।
हाँ।
उसके बाद इनका रिस्टोर हो चुका है, ठीक है।
Lordship,
Right.
ये advocate.
The matter was taken up on 2023. Appellant had paid for time which was allowed by way of last chance. Thereafter, the case was taken up and the appeal again which was allowed, and to date nobody appeared.
ये health issue की
I
कारण
will
वो
not-
नहीं हो पाए.
I will not permit this.
Lordship, ये और
मैडम सूट कब का? आपके जन्म के पहले का?
2016 का है.
सूट
ये ऐसे वही 2016 का है.
सूट कब का? Lordship, family dispute है इसमें. Lordship, दे दीजिए. Last देंगे आपको 2 लाख रुपए कॉस्ट। कोई
Lordship,
भी फर्स्ट अपील सेकंड अपील का रेस्टोरेशन बिना कॉस्ट के नहीं है।
Lordship, तो ये previous लैंड काउंसिल के गलती.
तो वही देंगे ना पैसा। जाइए बार काउंसिल में, उनसे पैसा वसूली कराइए।
Lordship, ये लास्ट टाइम जैसा नहीं होगा.
वो लास्ट ही चांस है 2 लाख रुपए देने का। अगली बार से वो ऐसा नहीं करेंगे।
Lordship, इसमें हम अपने Lordship वो काम है. इसमें मेरा एक ही एडवोकेट का नाम है, मेरा नाम है.
कोई बात नहीं। आपका वकालतनामा फाइल किया?
हाँ.
कहाँ है आपका वकालत?
ये मेरा नाम नहीं केस है.
इसमें तो सीएपी में तो कोई वकालतनामा नहीं फाइल किया।
ये आजकल लिस्ट में मेरा नाम है. सीएमपी
कैसे के नाम से? ये आप उसमें सेकंड अपील में नहीं?
सेकंड अपील में नहीं थे ये.
सीएपी के नाम से कैसे?
क्योंकि ऐसे में ये वकालत में फाइल गए थे तो ले नहीं रहा था. बोला कि जब तक सीएमपी स्टोर नहीं होगा ऐसे तब तक वकालत
तो आपका वकालतनामा नहीं है।
ये सीएमपी में है. फाइल करनी है तो फाइलिंग सेशन यही हुआ था. सीएमपी में नाम से.
No objection.
इसमें D3 आईए भी है सब्स्टिट्यूशन के लिए.
नहीं हाँ ये सब फालतू केस सब जो है ना
लॉर्डशिप इसमें एनओसी इसलिए लिया गया कि वो अप्लाई नहीं कर रहे थे. अप्लाई का इसमें तो फॉल्ट नहीं है. लॉर्डशिप एडवोकेट नहीं अप्लाई कर रहे थे हेल्थ इशू के कारण. इसमें तो मेंशन किए हैं और इसमें एनओसी लेके हम इसमें अप्लाई हुए.
I will not permit this.
लॉर्डशिप ये अब नहीं होगा.
नहीं तो 2 लाख रुपए कॉस्ट जमा करिए. वही सोच रहे हैं कि सीएम आइए डिस्कस करने के पहले 2 लाख रुपए कॉस्ट करें कि आइए पर नोटिस करके करें. नोटिस भी नहीं करेंगे, पहले आप कॉस्ट जमा
लॉर्डशिप
करें.
इसमें ना प्लेन का फॉल्ट है अभी नया वकालतनामा ही फाइल किया है.
सिस्टम का फॉल्ट है कि रेस्टोरेशन में हम लोग कॉस्ट नहीं लगाते. हम लोग की गलती है, माय मिस्टेक.
लॉर्डशिप
नहीं
नेक्स्ट
नहीं
टाइम
आपसे
आपसे
तो सब एकदम पार्ट साफ है. गलती हमारी है.
लॉर्डशिप नहीं होगा नेक्स्ट टाइम से ऐसा.
नेक्स्ट टाइम हम भी कॉस्ट नहीं करेंगे. 2 लाख से 1 लाख कर देंगे.
लॉर्डशिप
नहीं कर सकते. इस तरह का कंडक्ट में हम लोग नहीं कर सकते. कुछ नहीं हम सुनने वाले हैं. डिसमिस ही कर देते हैं.
लॉर्डशिप ये
नो
लॉर्डशिप इनका एक और चल रहा है उसमें लॉर्डशिप इसमें अलाउ
सीएपी नंबर 162 और 2025.
लॉर्डशिप अप्लाइड का इसमें लॉर्डशिप फॉल्ट नहीं है ना. वो डेली आके बोलते हो तो अपनी केस के लिए अप्लाई चले गए. एडवोकेट क्या यहाँ पे फॉल्ट आ गया.
क्या केस था आपका?
ये ऐसे था. ये फैमिली मैटर फैमिली डिस्प्यूट है. मुस्लिम जैसे अपीलेंट के जो फादर है उनकी 2 वाइफ है, उसमें से डिस्प्यूट है, लैंड डिस्प्यूट है।
और जिन लोगों का ऑलरेडी अबेट कर चुका है, जिन लोगों का ऑलरेडी रेस्टोरेशन इनका अबेट कर चुका है, उनका अभी हम सब्स्टिट्यूशन यहाँ पे अलाउ कर देंगे। कैसे करेंगे? रेस्पोंडेंट नंबर 10 को कैसे सब्स्टिट्यूट करेंगे हम लोग? बताइए। हाउ? अंडर व्हाट प्रोविजन ऑफ लॉ? The appeal was dismissed for non-prosecution by order dated 19/2/19.
हाँ, एक बार वहाँ हुआ था और एक बार यहाँ 4/3/2005 हुआ था for non-appearance.
CNP number 162 of 2026. This CNP has been filed for restoration of second appeal number 338 of 2016, which was dismissed for non-prosecution by order dated 4/3/2025, which reads as follows. Further, a petition has been filed for substitution of opposite party number 10, who is said to have expired on 22/8/2019. Another petition has been filed for substitution of opposite party number 8, who is said to have expired on 29/9/2025, along with petition for condemnation of DD and setting aside agreement. On the face of the aforesaid order dated 4/3/2025, dismissing the second appeal number 338 of 2016 for non-prosecution, this court is of the prima facie view that there has been gross negligence on the part of the this court finds that the second appeal was earlier also dismissed for non-prosecution and was restored by order dated 6/12/2019. And thereafter also, in spite of repeated opportunities being granted to the appellant, at his request, the appellant did not participate, and ultimately the appeal was dismissed for non-prosecution. The restoration has been filed by engaging another counsel, and it has been stated in paragraph 6 that on 4/3/25 the advocate on record could not appear as he was suffering from cough and cold. This court is of the view that there has been gross negligence in conducting the second appeal number 338 of 2026. And before entertaining the second appeal, before entertaining this CNP and before issuing any notice upon the respondents or even in the interlocutory application, some cost is required to be deposited by the petitioner. Accordingly, the petitioner is directed to deposit the cost of the case 50,000 in advocate clerk's account within a period of 8 weeks from today, failing which this CNP will stand dismissed without further reference to them. Post this case, if this order is complied, post this case on 31st of July. 50,000 रुपये कॉस्ट जमा करेंगे, उसके बाद
थोड़ा कम कर देते हैं उससे।
एक जीरो और लगा देंगे।
Attempt 10, CNP 203 of 2026.
पहले कॉस्ट जमा करिए, कॉस्ट, उसके बाद सोचेंगे क्या करना।
थोड़ा कम आपने कहाँ से भी दे पाएगा, थोड़ा कम कर दीजिए।
Yes, please. Second appeal, first appeal का कोई भी restoration हम बिना कॉस्ट के लाएंगे। वो सब चीज अपनी जगह। सेकेंड अपील, फर्स्ट अपील का कोई भी रेस्टोरेशन विदाउट कॉस्ट नहीं है।
कुछ पेज बच गया था, हैंड रिटन था, वो भी हम फाइल कर दिया। जब सेक्शन में पता चला कि 11 दिन का डिले से फर्स्ट टाइम था ये, सेकंड अपील ऑर्डर्स में डिफेक्ट में आया, कोर्ट ने जमा करना था और जजमेंट का कुछ टाइम वो हैंड रिटन था।
I will not permit this.
पेज नंबर लिखा रहा था जो
No, I will not permit this. No second appeal will be restored without cost. First ही टाइम कॉस्ट आपके ऊपर लगाएंगे, क्योंकि आपका फर्स्ट टाइम है। I will not permit this. मजाक बना के रख दिया रेस्टोरेशन।
इसमें मिस्टेक हो गया है पार्ट से।
तो मिस्टेक कौन बोलता है कि कर्मों का सजा नहीं मिलेगा? राइट? हर कर्म का सजा मिलेगा, फल। हम कहाँ बोल रहे हैं कि मिस्टेक नहीं? अभी तो रेस्पोंडेंट को बिना नोटिस किए तो हम रेस्टोर भी नहीं कर सकते। लिमिटेशन भी लगा दो।
11 दिन का इसमें सारा हम लिखे हैं कि कब डिफेक्ट रिमूव
इससे कोई फर्क नहीं पड़ता ना। सेकेंड अपील बिना नोटिस का नहीं रेस्टोर हो सकता, लिमिटेशन लगे चाहे ना लगे। CNP number 203 of 2026 with IA number 2453 of 2026. Issue notice to the respondents in CNP as well as interlocutory application. Few speed post and organic process for which requisites be filed within a period of by 14th of May.
All right.
Post on 19th June.
All right.
19 June.
Out of turn Mason case item 45, CRMP 262 of 2026.
This for restoration of criminal revision, the petitioner surrendered and filed supplementary affidavit. Sure.
Where is the surrender certificate?
Annexure 1, page 4, supplementary affidavit.
Where is the original? Where is the original? Surrender certificate original file. CRMP number 262 of 2026. This CRMP has been filed for restoration of criminal revision number 619 of 2021. Case dismissed on 17/5/24 for non-compliance of order dated 3/5/2024. The learned counsel for the petitioner submits that the only defect was regarding filing of surrender certificate. यही एक डिफेक्ट बचा था. The learned counsel has referred to the supplementary affidavit dated 30/4/26 and has submitted that the photocopy of the surrender certificate has been placed on record. He also submits that the original certificate will be filed in the main CRMP petition. The learned counsel submits that the CRMP be restored so that the case can be taken up on merit. Any objection? The learned counsel for the state has no serious objection so far as the prayer for restoration is concerned. After hearing the learned counsel for the parties and considering their approaches at facts and circumstances, the CRMP number, the criminal revision number, restoration and criminal revision under criminal revision number 619 of 2021 is restored to its original file. Office is directed to place this case before appropriate bench as per.
Item 11, CMP 216 of 2026.
For what? Counsel for the petitioner seeks settlement. Post on 11 September.
Item 12, 1st April 229 of 2026.
Number 557 is condition of delay to 10 days. Because plan the Friday mistake also file appeal civil appeal file also before the principal district judge.
Issue notice to the respondents in IA number 11524 of 20. Sorry, in IA number 5457 of 26 and also in the first appeal. दोनों में कर देते हैं specific performance का case for which requisites be filed under कहाँ के लोग हैं देवघर
जामताड़ा
जामताड़ा के नहीं देवघर और 3, 4 under speed post as well as ordinary process within by 14th of May 20. Post on 10th of July.
Item 13, CMP 307 of 2026.
Council for the appeals are present with the jury, ठीक है? उनका प्रेजेंस रिकॉर्ड करिए जो भी थे पहले नाम ना भी रहे कोई बात नहीं उनका अपीयरेंस रिकॉर्ड करना जरूरी है कभी कभी एक्सपार्टी ऑर्डर हो जाता है हाँ बोलिए यस
normal appearance post order is that of the Zaman government order 23 तारीख को फिक्स 10 तारीख को लेवी ऑफ कॉस्ट के लिए आगे फाइल किया
कहाँ है ऑर्डर कॉस्ट जमा कर दीजिए
और जमा नहीं किया
करिए ना कॉस्ट आइए कब फाइल कीजिए
10
आपको कब तक टाइम था आइए फाइल करके मेंशन क्यों नहीं किए
आइए प्रोसेस ये हम सेकंड लेवल में आए थे
हाँ वही तो हम भी जानना चाहते हैं आइए फाइल करके मेंशन क्यों नहीं किए
इस महीने में एंटर नहीं किया
बहुत अच्छी बात
17 तारीख को रखा है बगल में
ये सब नहीं चलेगा ये एग्जामिशन नहीं होने वाला दिस इज नॉट एन एक्सक्यूज आप 20,000 रुपये जमा करिए उसके बाद ही रेस्टोर करिए
रेस्पोंडेंट जो है कंस्ट्रक्शन वर्क स्टार्ट कर दिया
अच्छा ही है ना अभी कंस्ट्रक्शन का महल बना देगा वहाँ इससे नहीं होता है आई विल नॉट परमिट दिस सीएमपी में इंटरिम ऑर्डर आपको चाहिए कौन सा प्रोसीजर में आपको देंगे सीएमपी में इंटरिम ऑर्डर जो भी लिटिगेंट बोलता है फाइल कर देते हैं रेस्पोंडेंट्स को नोटिस हुआ था एडमिट हुआ था केस सेकंड अपील
ऑर्डर को तुरंत ले लेना है
I will extend the payment period for payment of cost. अभी तो ये DFD हो गया तो नोटिस करना पड़ेगा कैसे हम रेस्टोर करेंगे विदाउट नोटिस यू आर फॉर द स्टेट ओनली स्टेट इज द रिस्पोंडेंट सॉरी नहीं कर सकते रेस्टोर ही नहीं कर सकते हैं बिना नोटिस के 20,000 रुपये तो आपको देना ही पड़ेगा या फिर मेरे रिटायरमेंट के बाद इसमें केस करेंगे CLP number 307 of 2026 issue notice to the respond number 1 and 2 for which requisites under ordinary process and speed post be filed by 14th of May 2024, sorry 2026, entry, post on 19 June.
Offence filing item 14, WPS 196 of 2019.
There was a series of litigation prior to the acquittal order in the case. Now this person has been acquitted, which is the next step for your lordship. So after the acquittal order, the petitioner has sent representation on litigation, wherein the respondent has replied that no action can be taken, which is at annex 5 at page 83, which basically says that there is no action which can be taken in this
There is no
particular.
page 83 in my record. I don't have page 83 in my record.
So there was only the representation. There is somehow there is another complication which is there at page 83 in my record. So there was a representation which was sent after the acquittal order, but no action has been taken by the respondent. Basically, there was a misappropriation which was there in 2006. FIR was registered. Then there was a departmental inquiry. In departmental inquiry, he was disqualified from the service. Later on, in that particular FIR, he was acquitted. So after the
So what? Even if you are acquitted, the nature of proof is totally different. For departmental inquiry, it is preponderance of probability. They did not stay the departmental proceeding awaiting the result of the FIR. So therefore, it has got no bearing. The order passed in the departmental inquiry has attained finality. That's it.
maybe 1 week time may be given you. I'll just find few judgments. I'll try
No
to find.
judgment is required.
The acquittal order was not an honorary acquittal, Your Lordship. He was acquitted on the two grounds. Firstly, that there was no prosecution sanction against the petitioner, and secondly, that beyond reasonable doubt, prosecution has failed to prove the case beyond reasonable doubt.
There was lack of sufficient evidence.
Your Lordship may see page number 79 of the writ petition. Para 25, Your Lordship, if I may place, this is the judgment in the criminal case, Your Lordship. Considering all the facts, circumstances, and reasons as stated herein above, I find that the prosecution story is very doubtful, and the prosecution became completely failed to prove charge under forgery against the accused beyond shadow of all reasonable doubt. And Your Lordship, further there was a lack of prosecution sanction, Your Lordship, which is also clear from page number 75, Your Lordship, of the petition.
Page number
75, Your Lordship. The last paragraph, Your Lordship, contains the last 4 lines. And for reasons stated herein above, I find that the statutory requirement as provided under section 197(2) has not been complied with by the prosecution, and accordingly, in my considered view, the entire proceeding against the accused is hereby demolished.
Heard the learned counsel situated on behalf of the parties. This petition has been filed for the following reading. The learned counsel for the petitioner submits that the petitioner was subjected to departmental proceeding as well as criminal case arising out of the same incident, and he was found guilty in departmental proceeding in December 2006 and was terminated from service by order dated 25/7/2007. The appeal was also dismissed on 29/1/2009, and revision was also dismissed by the order dated 13/5/2009. The writ petition being WPS number 846 of 2010 was dismissed by order dated 5/5/2010, upholding the order of dismissal. And the LPA number 101 of 2011 was also dismissed by the order dated 19/8/2011. He submits that thereafter the petitioner has been acquitted in the criminal case by Judicial Magistrate First Class Ranchi by the order dated 28/3/2018 in DR case number 4491 of 2006. And the prosecution failed to prove the charge under section 409 of IPC against the accused beyond reasonable doubt, and hence the petitioner was held not guilty. The learned counsel submits that thereafter the petitioner has filed a representation dated
30th of July 2018.
30th of July 2018 for consideration of his order of acquittal. The learned counsel submits that once the petitioner has been acquitted in the criminal case, he is bound to be restored. The learned counsel for the state has opposed the prayer and has submitted that the order of dismissal of the petitioner on merits in the departmental inquiry has attained finality up to the LPA court, and the acquittal in the criminal case has no relevance. She submits that otherwise also the standard of proof in the criminal case is totally different from the standard of proof in criminal proceedings. In criminal case, the prosecution has to establish the case beyond all reasonable doubt, and departmental proceedings are conducted on the basis of the principles of preponderance of probability. The learned counsel has also submitted that on the perusal of the order of acquittal, it is apparent that there are two reasons for acquittal. One is that the prosecution sanction was not available, and the second was that the petitioner was, the prosecution's story was found to be doubtful, and the prosecution could not prove the case against the accused beyond all shades of all reasonable doubt. She has referred to the counter affidavit and has submitted that in the counter affidavit order dated 29/10/2018 has been placed on record, wherein the petitioner has been intimated that the representation dated 30/7/2018 submitted by the petitioner requires no action. She submits that this letter has not been disclosed by the petitioner in the petition which was filed on 8/1/2019, and no rejoinder to the counter affidavit has been filed. The petitioner is also guilty of suppression of material facts before this court. She has submitted that the request of the petitioner to reconsider his case on account of acquittal has been rightly declined, and the petitioner is not entitled to any relief as paid for in this writ petition. After hearing the learned counsel for the parties and considering the fact that the order of dismissal of the petitioner on merit on the basis of departmental proceedings was contested by the petitioner till LPA court, and ultimately the order of dismissal, and ultimately this court refused to interfere with the order of dismissal. So far as the criminal case is concerned, the petitioner has been acquitted on the aforesaid two grounds as pointed out by the learned counsel for the state respondent. The learned counsel for the respondent has rightly submitted that the acquittal in the criminal case has no bearing in the matter on the grounds she has asserted. Considering the totality of facts and circumstances of this case, the petition is not entitled to any relief. Accordingly, the petition is dismissed.
Item 50, DA.3438 of 2026.
Twice, once withdrawn and once rejected by your leadership. February only. Only thing.
What do you want?
No antecedent. Cybercrime, no antecedent. And he is in custody for 13 months, near about. No first offender. Leadership may kindly see the order. And yeah, it is an annexure 1. Page 14 it starts. The only ground of rejection is the same as
Once it has been rejected, what relief can I give you? You just tell me.
relief is
What
that
is the stage of the case?
Stage is that out of 15 witnesses, 2 has been examined. Charge has been framed long away.
When?
Yes, madam, I'm giving the date. Charge framed on 18/9/2025. On 17/10/2025, witness was absent. On 7/11/2025, the witness was absent. On 27/11/2025, the witness was absent. On 15/12/2025, the witness was absent. On 6/1/2025, absent. 27/1 absent. 27/2/2026, 2 witnesses
The
were
informant and IU are remained to be examined.
Only 2 has been examined.
Are remained to be examined. Page number 44, bottom. The informant and IU are remained to be examined.
15 named chargeable witnesses, out of which 2 members of the leading party has been examined. Out of which
Informant and additionally they are
IU are remained present.
Are remained
Last
to be
witnesses have been
examined.
examined. 1 and 2 have. That is what I am saying, madam. 1 and 2 not remain to be examined. Only 2 witnesses have been examined. That is, I am giving the dates from the on each date, and 15 witnesses are there.
I will expedite it.
Some consideration.
Once rejected.
I do, madam, but now this is the first offender, madam. Only on that ground.
First offender को ये सब भी थोड़ी बनाना है।
नहीं वो
मतलब हम अपने parameters के हिसाब से।
Parameters, but I'm not saying anything, madam. Since yesterday also in similar cases, madam, I have.
Not a similar case.
Not similar, madam. Obviously not. As your leadership pleases. But some time.
और उसमें तो हम already दिए थे।
हाँ already दिए।
अब तुरंत आप आ गए हैं।
Custody का ground.
कस्टडी कैसे अभी 17 फरवरी को
हम बोल तो रहे हैं
कितना
स्टेज ऑफ ट्रायल कॉल फॉर कर दिया जाए
नहीं कोई स्टेज ऑफ ट्रायल करते
सिर्फ इतना ही स्टेज ऑफ ट्रायल कॉल फॉर कर
DA number 3438 of 2026 heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the bail application of the petitioner was earlier dismissed as withdrawn in BA number 6228 of 2025 by order dated 9/9/2025 and thereafter on 17th of February 2026 the bail application was rejected. However, there was a direction upon the state to ensure prompt production of witnesses. The learned counsel submits that thereafter the petitioner again moved the learned court on 25/3/2026 and the impugned order reveals that the last witness was examined on 17/2/2026. Next date कब था?
नेक्स्ट डेट
नहीं लिखा.
नेक्स्ट डेट
The learned counsel has submitted that out of 15 witnesses, only 2 witnesses have been examined so far. The learned counsel for the state has opposed the prayer and has submitted that the impugned order itself reveals that on 17/2/26 itself, 1 witness was examined and the impugned order is dated 25/3/2026 and nothing has been mentioned as to what was the next date in the case and as to whether the witness was produced or not.
No, 2 witnesses have been examined.
उसके बाद 25 दिन के बाद
No.
17 तारीख को तो किया ही नहीं।
कोई विटनेस क्यों आया नहीं?
डेट कब था?
That
वो भी नहीं पता। We considering the fact that the case of the petitioner has been recently rejected on 17 February 2026, asking the state to promptly produce the witnesses. No fresh ground is made out. Accordingly, this petition is dismissed.
yes.
For admission, item 16, CNP 318 of 2007.
अब क्या करना है भाई इसमें? हो गया सारा वकालतनामा हो गया आपका?
हाँ साहब हो गया। Restoration of 35
हाँ? Restore कर दे।
of 38 of 2000.
ये restoration to the power 3 हो जाएगा कि क्या हो जाएगा?
Yeah, this is the second restoration. As of
I just
35 में second appeal. ये 35.
CNP number 318 of 2007. For the learned counsel appearing on behalf of the parties. This petition has been filed for restoration of CNP number 38 of 2005, which was dismissed on 24/1/2026 for non-compliance / part compliance of court's order dated 9/1/2026. Defect removal का था? Order in connection with removal of defect. और भी कोई था?
Defect in the
Previous CNP. The learned counsel for the petitioner has submitted that the CNP was listed on 38. CNP number 38 of 2005 was listed before the bench on 9/1/26. And notices were issued. But due to inadvertence, the processes could not be filed completely. And there was some communication gap. The learned counsel for the opposite party has submitted that there has been gross negligence on the part of the petitioners. After hearing the learned counsel for the parties and considering the opposite facts and circumstances and the fact that the matter arises out of second appeal number 218 of 2004, which stood dismissed in CAP number.
May I request? I petition the EA is there to consideration of delay of 516 days. IA is there, IA number 210.
The IA number? 2109. The learned counsel, अभी आपकी petitioner का ही लिखिए. The learned counsel for the petitioner has also submitted that the petition for restoration in CNP number 38 of 2005 is also barred by limitation of 516 days, for which a separate IA number 2109 of 2007 has been filed. पेंडिंग दिखा रहा है आइए नहीं इसमें नहीं होगा इसमें आइए पेंडिंग हमको लगता है वो आइए कंडोम कर दिए Mr. Mehta, why the RA is not showing pending?
No, yes, mother. It has been one.
RA आपको नहीं पता आपका केस का डिले कंट्रोल हुआ है कि नहीं? delay in filing substitution.
सब्स्टिट्यूशन का ये होता है, लॉ होता है, ये रेस्ट्रिक्शन जो फाइल हुआ इसमें
आईए नंबर कितना है?
2109 of 2007 for continuing delay in filing this change.
ये पेंडिंग नहीं दिखा रहा है क्या?
नहीं इसमें
Because there is one more ID number, that is ID number 1429, 2015.
ये सब हो चुका
ये सारा
है, ये पहले हो चुका है, ये अभी हो चुका है, हम एग्जैक्ट डेट भी 1429 पहले कथा उसका व्यवहार हो चुका है।
ये अलाउड है।
पेंडिंग बता रहा है
कम कहाँ से बाबू
कंप्यूटर में नहीं दिखा
ये स्टेटस बता रहे हैं
क्या?
12/12/2025
कब डिस्पोजल है?
12/12/2025 को डिस्पोज दिखा
12/12/2025
स्टेटस
तो आईए नंबर 15942 है।
2109
09 कम से डिस्पोजल है।
उसमें ना वो जो 12/12/25 का ऑडिट है उसमें लास्ट में ना लिखा है कि ऑल द पेंडिंग आईएस ये मतलब वो डिस्पोज ऑफ हो गया था नॉट प्रेस्ड करके, तो इसी वजह से
All
शायद
other pending intellectual as not placed. ये आपका डिस्पोजल हो गया। All other pending आईए are not placed.
यस बिकॉज़ वो सब्स्टिट्यूशन का ही था, ये खाली जो है ये लिमिटेशन फॉर फाइलिंग दिस,
तो वो भी तो आप डिस्पोजल कर दिया as not placed।
उस दिन जो था ये नहीं था, ये दिस
What do you mean ये नहीं था? उस दिन ये पेंडिंग था। It was pending on that day. Yes, it was pending on that day.
थोड़ा हम वेट करें।
नहीं सेकंड
Second
मिनिस्टर
half.
नहीं सेकंड हाफ में नहीं, हम इसको हम रख ही देते हैं हम 2-4 साल बाद। It is impossible मिस्टर मेहतो, I just can't do anything about it. नहीं चलेगा। It is simply impossible. What is this? Restoration to the power 4. Just think of it. हम नहीं जानते मिस्टर मेहतो, I just can't do anything about it. इतना नेग्लिजेंस हम तो नहीं इमेजिन कर सकते। It is beyond my comprehension, absolutely beyond my comprehension. कितना आप नेग्लिजेंट हो सकते हैं, लिटिगेंट का तो छोड़ दीजिए। How can you be so negligent? और 15 मिनट से हम लोग खोज रहे हैं। I just आपका ये केस हमको देखने से हमको फ्राइडे को टेंशन हो जाता है, हम इसको आराम से रख देते हैं, हम नहीं करेंगे इसे, हमसे नहीं होगा। अब आप अपना रेस्टोर कराइएगा आपको जब मन। कुछ नहीं, देखिए सब काट दीजिए। During the court proceedings, it transpired that IA number 2109 of 2007, which was filed for condonation of delay in filing this CFT, was also disposed of as not pressed by the order dated 12/12/2025. Also for the petitioners seek adjournment. Post on 31st.